My name is Laura Baldwin. Ooh, is this too loud? Is this okay? Okay. My name is Laura Baldwin. I'm an attorney. I've worked with the Hennepin County Public Defender's Office for many, many years. I've been an attorney since 2006. I practice almost exclusively in criminal law, a little bit of civil practice. I've practiced in felonies, misdemeanors, juvenile, and I'm here today to talk to you about some of the rights that you have when you're interacting with police officers, and how you can exercise those rights safely, what some of the things to look out for are, and then to answer any kind of questions you might have about the law and how it might interact with your art practice, protest practice, or any other area of your life. If there's a question that I don't know the answer to, I'll let you know, but I should be able to at least figure out who you could ask so you can get the answer. But the goal today is just to really talk to you about your rights, talk to you about any questions you might have, and ideally you'll leave today with a better sense of security and how you can be safe when you are expressing yourself. Does that make sense? Okay. So I'll just, do you want me to just start with general rights that you have when you're interacting with the police? Okay, if anybody has questions, please just jump on in. You have constitutional rights, both under the Minnesota Constitution and the federal Constitution. Oftentimes people think that the federal Constitution is the best power to protect you, right? That's not my experience as a practitioner of law. People oftentimes forget about their state constitutional rights, which are oftentimes broader than federal constitutional rights. Oftentimes they're mirrored, but practically, usually the state rights are of greater value than federal rights. Your federal rights, however, are what you're more familiar with naturally. And that includes your right to assemble, your right to be able to say what you wish, the right to worship as you wish to, and those rights cannot be infringed upon. Sometimes you see that infringement happen, though, specifically in the area of protest. So for example, if you see something that's outrageous, if you see a police officer doing something abusive, as we saw with the George Floyd case, and the Derek Chauvin case, if you see that, how do you interact with a police officer safely? If you're in public, you're entitled to protest. If you're on a public square, if you're in a public park, if you're on a public street, you have the right to be there and you have the right to say what you wish to. You have the right to protest peacefully. If people don't like what you're saying, that's not something that's taken into consideration. So you have the right to express yourself in a public forum. If you're in a place such as this, MCAD, in a privately owned space that is accessible to the public, there can be restrictions that are placed on your ability to access this area or your ability to use this area. If you go to the street right over there, then those prohibitions are less enforced. They're less able to be enforced. You can be told to move aside to allow for traffic to pass. You can be told to move aside to allow for people to walk through the area, but you cannot be told to stop protesting. If somebody wishes to counter-protest you, they can do that, and the police are entitled to separate you from counter-protesters, but they're not entitled to quiet you. If you are engaging in something that is would be considered obstruction of legal process, that is something we frequently see, and it's basically if you piss off the cops, if the cops beat you up, if you are interfering with their ability to perform a lawful duty, that can be considered a crime and that can lead to your arrest. If you're considered to be trespassing. So if you are protesting here and MCAD comes out and says, we do not allow you to be here, you are trespassed from the school property, then you're not allowed to be there. And even if there's a reason why you want to protest here, they have a right to prevent you from being on school property. Then you'd have to move to the public street. You can be on a public street directly adjacent from wherever you want to protest, and that's fair game, but being on their property is not. So they can limit how you express yourself on private property, not on public property. If you are interacting with a police officer in the course of a protest, they can limit sound amplification. They can limit crowd sizes. They can require permits for larger crowds, or if you're going to shut down the street, but they can't prohibit you from speaking your mind. If for any reason you're in a course of a protest or in any other kind of interaction with a police officer and the police officer asks to talk to you and you don't want to talk to them, you can just say, I don't want to talk to you. And if they persist, you can say, I would like a lawyer present when I talk to you. As soon as you say the words, I want a lawyer, that's one of the magic words. I want a lawyer means that they are shut down from asking you questions. That means they don't get to interrogate you. That means all of that questioning can stop. It may mean that whatever investigation they're engaged in doesn't allow you to participate in it. So that could be, so it could be if they're looking into something more serious, a riot or an assault or something like that. They may decide to charge you because you haven't cooperated in talking to them, but they cannot force you to talk to them. They can, however, if they're investigating something big or if they're investigating something that that they're taking particularly seriously. If you ask for a lawyer or you ask not to talk to them, what they can do is just present you with information. And the purpose behind that is to goad you into, trick you into saying something that's going to be incriminatory or that's going to make it seem like you've committed a crime or you may be guilty of something that they're investigating. So we see that a lot. I see that a lot with like homicide cases, rape cases, or aggravated robbery cases. Usually kind of higher end cases, but a case where the police are actively looking to solve a crime quickly. Oftentimes what they'll do if the person says, I don't want to talk to you, they will begin with surveillance photographs, other information, other investigation that they've conducted so far. They'll present that information to them. Here's a photograph of somebody that looks like you committing the crime. Here's a photograph of somebody like you interacting with these other people who are of interest to us. Here's a photo of you making a phone call. Here's a photo of you at the scene. And your job in that moment, if you're smart, is to remain silent. The cop is not questioning you. She's not interrogating you. She's not, reading you the riot act or anything like that. She's simply presenting information. So it's not an interrogation. But it's tempting to respond to it, right? Like you want to be able to say that's wrong or you've misunderstood this or whatever. And that's where they can kind of goad you into things. So you just have to be on the alert to that if you're in that situation. Do you have a question?
How much are the police allowed to lie to you when giving this information? Are they allowed to tell you things that are like clearly and obviously false?
How much are the police allowed to lie to you? They're allowed to lie to you.
Okay.
There's no prohibition on that. And they do that all the time. I mean, what they usually do with that is to say, we have a lot of good information. Or your co-defendant, the person you were arrested with, they're in the next room over and they've told us everything we need to know. And oftentimes there's a grain of truth to that, right? Like, they've told you something. They've told you their name. Maybe your co-defendant has said their name. They've told you, they've said their address. They've said their grandmother's address. They've, given some little detail. So the police officer, if they're any good, will go back to the room that you're in and they'll say, your buddy over there who was arrested with you gave me this detail. And they can elaborate from that. They can extrapolate. They can create a story from that that will convince you to confess or to try to mitigate your guilt by talking to the police. That's a technique, and it's an effective technique. It works a lot. But it is a technique to get you to admit something that will incriminate you. So does that make sense? Do you guys have any other questions about that? I don't expect that would come up very frequently with you, but when it comes up, it comes at you kind of quickly, and it's good to know that you need to say the magic words, which are, I don't want to talk to you, I would like a lawyer, and then if they continue to give you information, understand that what they're trying to do is elicit information from you, elicit a reaction. It could even be just a physical reaction, or what I've seen in interrogations are the police officer giving some piece of information. Your buddy's already confessed and he implicated you. And then the next sentence of a police report is, I told him this and I saw him shrink back. He hung his head. He shivered. Like some of those physical reactions, that becomes part of evidence. So you have to be really alert to those techniques that police officers have when they're interrogating you.
Hey Laura, what if you're in a group situation? I think one of the reasons that some of the students were interested in organizing this were ideas of like impending protests that they may be involved in, and maybe some of them have not had experience in situations like that. So if you're involved with the police in a situation like a protest, and maybe you're then cordoned off by yourself or you're corralled in a group, what are some things that you think you should look out for in those types of circumstances?
Yeah, so if you're in a protest and you're corralled in a group, you can really easily be kind of lumped in with other people who may be doing stuff that you're cooperating with, maybe not. you have to, I would advise people to make an effort to understand which officers you're dealing with, so you can ask for officer badges. Understand that most officers, especially in the city of Minneapolis, do have body-worn cameras. So everything that they're doing with you and everything you're doing to them is being recorded. If they're being disrespectful to you, if they're lumping in you with other people, that will all be on their body-worn cameras. And so you can ask in that, you can take action within that moment to protect yourself. Things you can do to protect yourself are to say, I'm not with these other people. You can say, I'm peacefully protesting. I'm expressing my First Amendment rights. And that's all. I think it's in your interest to be respectful and to be very clear about that and to be clear about what you're doing there. I'm on public property. I'm expressing my First Amendment rights. I'm peacefully protesting. If you still get lumped in with them, again, cooperating with them, with the police and like listening to what they have to say is going to be valuable. So if they're saying simply get out of the way, like get off the sidewalk or get to the side of the sidewalk, that's one thing. If they're telling you that you are no longer allowed to protest, that's a different thing. They're not technically allowed to tell you that you cannot protest or that you cannot be in a public space. However, if they violate those rights, you have to make a choice. You have to make a choice about whether you're going to walk away from that situation and simply disperse as the police officer is asking of you, or you can choose to remain where you are and continue your protest. If that happens, the police may detain you for a temporary period of time. They may detain you and bring you down to the public safety facility or the Hennepin County Jail or the county jail for wherever it is that you're protesting. If that happens, again, you're going to want to say that you don't want to talk to them. You can be held for a period of, it's usually up to 48 hours. That does not include weekends or holidays. The more standard time frame is 36 hours. On the weekends, a judge will review a case to see whether or not a person should remain in custody or whether a bail would be set. It usually happens on Saturdays. But you can be held, so say you get arrested on like a Friday afternoon, it's possible for you not to have your case reviewed by a judge until Monday morning. And so you may remain in custody for a period of a weekend. Generally speaking, protest cases, a person is not going to be held in custody. It's usually the kind of charge that comes from a protest case would be disorderly conduct. If you're in a group of 3 or more people, that could be considered riot, which is a more serious charge. You could be considered it could be considered obstruction of legal process. There are different other charges that could be levied against you. Most of them are not going to hold you in custody. And most of them are not going to be the kind of charge that will interrupt your life moving forward. But upon arrest, you can be held in custody for up to 36 hours. You can be granted a bail. You will be given a hearing before a judge within 36 to 48 hours business days. And you would have significant court interaction from there. So you may have a number of court appearances, a trial, you may have a lawyer appointed to you, and a prosecutor that you're working against. So it can be an involved process if you get charged. The reality is that resources are sort of scarce. Oftentimes with protests, there is not a great interest in following through with charges. For example, during the protests after the murder of George Floyd, I had a lot of people call me who were arrested for protesting. None of them were ultimately charged. They were just trying to pull people off the street and pull people out of the arrest area.
Okay, sorry, did you have a question?
I did. What do we do if we see like one of our friends or somebody else, a stranger, being profiled and no native people?
Yeah, good question.
Could
So
you
if
repeat that
Oh,
question
yes.
for everybody?
So if a person is being profiled, or if they're being harassed by a police officer, the question is, what do we do about that, right? If you're out in public, a police officer does not have a right to privacy in what they're doing in a public area. So you have the right to film them. We saw that with George Floyd's murder. We saw a teenager who bravely filmed the police officers doing what they did to him. You have that right. You cannot go into a private space. They have a right to privacy in a private space. So you can't like go into their car or interrupt a police car's movement. You can't interrupt a police officer's execution of their lawful duties. And I think it's probably in your interest not to question whether a police officer is engaged in a lawful duty, because they're going to say that they are and they're going to react to you, unless you're ready to take that plunge and deal with the consequences of that. But filming is going to be useful, getting a officer's badge is useful. Keeping in mind that the police officers do have body worn cameras, so they are recording everything. You can ask the person who is being profiled or harassed what their name is and get their contact information, or provide your own name and contact information. If you do that on body worn camera, then obviously it is something that's going to be made available to them if their case is charged. There is a certain amount of courage that has to come with that, because you're also giving your information to police officers, and you have to trust that they're not going to hassle you. Again, that's a choice that you have to make about how comfortable you are with that risk. Yeah. Oh. Yeah.
That question and then get over to you.
I wanted to ask, didn't the police officer, like, if they want to arrest a protester, can they say that it's like a riot instead? Like, what's the difference between protest and a riot?
Good question. So a riot, it just means that it's 3 or more people engaged in activity that is illegal. So if you and 2 other people engage in boisterous, loud, obnoxious, belligerent behavior in the
Which
eyes
is
of the law,
Basically being in public to a cop.
then that, if it's with 3 or more people, then that is a riot, and that would be a gross misdemeanor charge. So when I've seen that, you can, depending on what level of boisterous behavior there is, it can be very serious. Like I think the least serious riot case I've ever had was somebody who kicked over a trash can or something with their buddies, and that was considered to be a riot.
But is that different than just like yelling something?
Yelling is disorderly conduct, so that's a lesser charge. But if you do it with 2 or more people, then it's a riot. If you do it in a way that obstructs the police, then it's obstruction of legal process. I mean, you can see how something fairly benign can turn into something more serious depending on how the police officers interpret it and depending on who you're with. So oftentimes in that scenario, if you may be with 2 people who are acting like jackasses and you're just kind of there. But if they think that you're looped in with them, then all of a sudden all 3 of you are in trouble and all 3 of you are guilty of riot, even if you're having a relatively benign role in that event.
We have a question over here.
Okay, so jumping back to what you said previously about Soren's question about if you see someone getting profiled, can you interfere? Like, you said ask the badge number, can you do that while they are profiling the person, or do you have to like wait, or how would you go about doing that?
You can ask the question.
Could
So
you repeat the question
yes.
as well?
So the question is, if you see somebody being profiled, to what level can you interfere? Can you ask the officer while they're interacting with the person who's being profiled? What is the limit on how much you can interact with the officer during that, or how much you can interrupt the officer? Is that correct?
Yeah, or interrupt. Yeah,
Sure.
yeah.
You can't interrupt the officer. That is obstruction of legal process. So you can't prevent them from engaging in their lawful duties. And lawful duties are in the eye of the police officer usually. You can litigate that later, but functionally you can't make them not hassle that person or investigate something that they believe to be unlawful. You can ask for their badge and they can tell you that they're in the middle of something, and they should provide that to you. The policy is that they should make an effort to provide that information to you. Obviously that means if they can, which is again in the eye of the beholder. I would say that the safest thing that you can do in that moment would probably be recording. I do think that there's a humongous power in recording things. I can see that from body-worn cameras. In my work, I receive those, and I can see how police officers interact with my clients and how my clients interact back with them. Same thing with a cell phone. I mean, theoretically, there's nothing to hide. They have no reason to believe that any of their interactions with any person should be confidential or should be anything to hide. And so, to that end, you have the right to film them. You have the right to ask them why they're interacting with the person, but they don't have to respond to that if they're in the middle of their investigation. After the fact, if the person is arrested in the back of the squad car, that would be a good time to write down the squad numbers. That should be on the side of the squad car. That's also a good time to ask them for their badge information. They should have business cards on them that have all of that information and they can provide that to you. They also have the ability to give you what's called a blue card. I don't know if anybody here has ever had to report a crime, but police oftentimes will give something called a blue card, and that will have a case number that relates to the case that they were investigating, and as well as numbers to follow up with. You can always call their sergeant. I mean, the sergeants don't give a shit if you don't like cops are acting. It's not going to make a difference, but it will have all of that contact information, and then you can follow up. One thing you should know, though, is that if a case is not charged, or if a case is pending disposition, meaning a person is facing charges but the case hasn't been settled in the courts, then information related to that case, police reports, that kind of stuff, is not going to be considered public, so you're not going to be able to follow up on that to find out what happened. After a case is closed, you can use the Freedom of Information Act to find out not only the disposition of the case, but to find information from the police reports, information from collateral sources, anything that's not confidential. If you were
Tanner, you have a question, but before you finish that, hypothetically, you're in that situation. You're attempting to be an advocate for somebody who's being harassed by the cops. It is not unusual within that moment if you say, hey, I'm filming you. No, I'm not going to stop filming you. That the cops can see that as, often we'll see that as like a point of escalation and think of that as like, oh, you're obstructing legal process or you're doing X, Y, and Z. And even though you are not, it does come with the possible collateral damage that then, because you are kind of staying there and attempting to be an advocate, they might charge you with something, correct? Not that it will hold,
Not
but
that it will hold.
that is a possible consequence of doing such a thing.
That's always a possible consequence.
Yeah.
Like whenever you're interacting with a police officer, and I'm not saying all police officers are the worst, like
Yeah.
I'm not in that camp necessarily, but
Yeah.
they do have a lot of power, and so if they want to interrupt whatever you're doing, the way that they would do that is to arrest you on something like disorderly conduct or obstruction of legal process, and that at
Yeah.
least incapacitates you for a period of time, so that you, before they release you from custody.
So with that in mind, with that being a possible consequence, what are some of the magic words in an instance like that, or action steps you should take to put yourself in the best position, post arrest, if there's a possible charge or trial?
Sure. I think, well, starting in the moment, if you're seeing that and you make a choice, if you're seeing somebody who is, to your mind, being abused or who a police officer is interacting with in a way that you think requires documentation, I would say begin documenting. Use your phone if you can. If you don't have a phone, just write down what you can: description of the person, description of the police officer. If you have any, if you were able to see a number on the side of a squad car, write that down. I would say if you are filming or recording or just observing, you're going to want to say, I am observing, I'm in a public space. You're going to want to say, I am exercising my right to document this public interaction. You want to make sure that you are away from the actual action. So if the police officer is right over here, you want to keep a safe distance so you're not interfering with their physical actions. That's where usually people get jammed up with obstruction of legal process. So you want to keep a little bit of a distance. You want to observe. You want to mention that you are engaging in exercise of your rights. If you think about the awful video of George Floyd that that teenager filmed, she really did a perfect job of filming from a distance, persistently, in such a way that they were not able to nail her with anything. You know that those officers wanted to. You know that they would give anything to have ripped that phone away from her, especially Chauvin, who's now serving 25 years, something like that.
Yeah.
But they couldn't, because she was exercising her rights properly.
It kind of goes with your question.
Okay.
I know there's several cops who taken people's phones and they just grab it and slam it on the ground. What do you do in that scenario? You're recording and you're practicing your right of observing, and a cop destroys your own property. What do you do then? And to stop you from recording them in the act.
Cool. Did everyone hear that one?
So what do you do if a police officer grabs your phone and breaks it, or confiscates it such that you cannot film? You want to vocalize that so it's on their body cam and everybody else is able to hear it. A lot of this is vocalizing things. So saying, you have taken my phone, you have broken my phone, I was recording this because I think that you're acting improperly. In the moment, I would say that you want to vocalize, but you don't really want to do much more. In the act, you are able to get that officer's contact information, especially if they've broken your property or interfered with your property. You would want to collect any information to identify other officers who are there. Again, if the officers are obstructionist about who they are, about their identity, they won't give you badge number, they won't give you a blue card. Oftentimes you can use their squad to figure out who they are, because those are assigned usually to individual officers or pair of officers, and that assignment will be noted, so you can figure out who you're dealing with, and you can talk to their sergeant. Functionally, realistically, I mean, you could, I guess, take the city of Minneapolis or the city to Swan Plains Court. Sometimes but my expectation would be that the police department would be obstructionist about property that they've damaged. They would identify a way that you were responsible for the property that was damaged. I've tried to move them to the side of the sidewalk, and because they were resisting towards that, their phone fell and was damaged, but that was not my fault. That kind of stuff is pretty common. So I wouldn't expect to get the phone back, but in terms of you exercising your rights and being able to protect or preserve what you were hoping to record or hoping to document, I would say that the best step that you could take would be to vocalize what happened. I was filming this because I'm concerned about the rights of this person. You have broken my phone, you have taken my phone from my hands and thrown it on the ground. I would step back at that point, like just get out of the way, but vocalize. They can't do anything about you when you vocalize. Yeah.
I was wondering specifically about pat downs, searches, like in the moment, like especially if you were just like filming and then they come up with a reason to like arrest you or whatever have you, and they're searching your phone, they're searching you, they tell you to unlock your phone. Like, what do you do in like social media? What do you do in that circumstance, and how would they go about like prying into that?
Good question. So you always have the right to be free from illegal search and seizure. That's a Fourth Amendment right, and that includes all sorts of stuff. So if a police officer stops you, you have the right to say, am I free to leave? And the police officer has to articulate whether you are not free to leave or are free to leave. If the police officer is just like fishing, like just seeing if you've done something wrong or like stopping you for the sake of bothering you, and they don't have a reason to stop you, then they have to tell you that. So they do have to say you are free to leave. You're not being detained. If you are being detained, you can ask why. If you are being detained, the police officers have the right to pat you down to see if you have any weapons on you. That's all that they're supposed to be doing. Sometimes I would say 99.9 times out of 100 they do a lot more than that, but that's all they're supposed to be doing, patting you down for officer safety when they initially interact with you. That can mean feeling the outside of your pockets. They're not supposed to go into your pockets. They're not supposed to go into your phone. If they believe that there's a reason that they might be endangered, if they think you might have a weapon on you or something that could hurt them, then they can search more diligently. They can search you. What I've seen is an excuse for for officer safety would be it can be benign. It can be just checking your pockets. It can be a strip search. It can be going into your butt or your vagina. It can be pretty invasive under certain circumstances. You can say to them, again, vocalizing things is helpful. I do not consent to this search. I am exercising my Fourth Amendment right to be free from illegal search and seizure. I do not believe that there is any probable cause to search me. I do not believe there is reasonable suspicion to search me. Vocalizing that is going to be helpful. It's not going to stop them from doing it in the moment, but it does mean that there's a record and the cops are on notice that you have not consented. If you are charged with something after the fact, your lawyer can help you because you've vocalized that. Does that make sense? In terms of your phone, so police officers can confiscate your phone, and they oftentimes do. This is like a super interesting area for me because I see kids especially, getting screwed with this. A phone is something that has like everything about you, right? I mean, if you really think about it, what's that? Oh, sure. Sorry about that. A person's phone really has everything about them. And I think about my phone has my children's information and their photographs. It has my address, it has my credit card number, it has all sorts of stuff. It has my social media accounts, it has my contacts, it has text messages and photographs, it has all sorts of information. If a police officer confiscates your phone, they're not allowed to get into that information, with some exceptions. If they confiscate your phone, they can ask for a search warrant from a judge if they believe that there is probable cause to believe that there's something illegal on your phone. Evidence that is commonly found on a phone would be evidence of drug transactions, evidence of photographs of a person with other people. You see that in gang cases a lot. If they think Laura Baldwin's client is probably in a gang, they might take the phone, get a search warrant, look into it, and see if Laura Baldwin's client hangs out with these other guys who are in a known gang, or who have committed a murder, or who have known to possess drugs or guns, or who are engaged in some sort of activity that is considered to be antisocial. In order for them to get the phone, they have to be able to demonstrate that to a judge, and then they can look at the information in the phone. If your phone is locked, then it depends on what kind of way it's locked, whether or not the police can get into it. So for example, if a police officer took my phone and a judge allowed them to get into my phone, and my phone was only protected with a Face ID, then they can take my phone with the warrant and stick it up to my face and use my Face ID to unlock my phone. Even if...
Yeah, let's say you're on the street with
Oh.
your Face ID. Can they take your phone and put it up to your face and then look through it because
No.
it's now unlocked?
No, only with a warrant.
But
But they might.
hypothetically, let's say they do that and they look through things, even though it's not admissible, what might happen then?
If a police officer was able to get into your phone and looked through things, then what would probably happen is they would continue to confiscate your phone, and they would utilize the information that they found to support a search warrant, so they could legally access the information in their phone. That's something I've seen pretty frequently. Turn off, yeah. The comment was turn off your Face ID. If you're in a situation where you think that police officers would have a reason to confiscate your phone or look into your phone, or you think you might have something that's of interest to them, my recommendation would be to not carry your phone to a protest, frankly, or if you know you're going to be in a situation where you may have to interact with a police officer, don't bring your phone. Full stop. If you take your phone with you, understand that with technology as it is today, a police officer could confiscate your phone. They could look into it. That would be illegal. You'd have to address that after the fact. With your phone, they can find out where you are. They have technology now where if you have, like Google Maps as an example on your phone, or if you ever use location service for any app or whatever, that means that your phone is trackable. So if a police officer confiscated your phone and got a search warrant, one of the things they can do is pull your location data. And that can be so specific. It used to be that it would triangulate from cell phone towers, which meant you could figure out where a person was within like a mile and a half, which is pretty good. But now with Wi-Fi technology and how many houses have individual Wi-Fi, you can ping a phone off of Wi-Fi. And that means you can find out where a person is to within like 100 feet. So an example of how that can be used, I had a homicide case a few years ago that wherein my guy had a cell phone on him, and it showed him walking up to the scene of the murder 12 seconds before the murder happened, and then taking off, and then the cell phone made it to the Mississippi River and disappeared. So presumably he threw his cell phone into the river. But it was amazing what accuracy they have for that, where a person is, how they've been using their phone, where they went. There's a lot of information that can be had. A police officer has to have a search warrant in order to get that. They can access that if you have a thumbprint access or phone or Face ID, but not with a passcode. So if you have a password, Even with a search warrant, you cannot be compelled to give a police officer your password, and they can't hack through the password. I've never seen them do so. So that can be a way around it.
I have two questions. Number one, what should we, let's say for whatever reason, we are detained and taken to the back of a cop's car when we did not do anything wrong, what should we not say? to
Nothing.
them?
You should say nothing.
What if they start asking you questions? Are there things that you've commonly seen people say that have gotten them into a lot of trouble when they haven't really done anything?
Yes. So another technique that I see police officers utilizing is keeping somebody in the back of the squad car. Everything that's in a squad car is recorded, right? So you see people sometimes just like kind of sit in the back of a squad car forever, for like an hour or two, especially actually in protest situations or something like that. In part because oftentimes they're trying to sort out who's done what or where the disturbance is coming from. By sitting somebody in the back of the squad car that is recording, people will sometimes start talking to themselves. They'll say, I can't believe I listened to that guy. I can't believe I did this thing. I can't believe, man, those cops are pussies. They never found the gun or whatever, like they say all sorts of stuff. And that can be used against them, obviously, once they get to court, if they come to court. My recommendation is to sit quietly and respectfully. What's real is that officers have to decide who they're putting their attention towards, and if you're the quiet one, oftentimes they'll move on to somebody else. So.
Part two, and then over to fast.
There's also a question.
Oh, and there's a question over here.
It's a part two, kind of.
Yeah.
What are your Miranda rights?
Miranda rights. You have the right to remain silent. Everything you say can be used against you in a court of law. You have the right to an attorney. If you can't afford an attorney, one will be provided to you at no cost. Before you talk to a police officer, you have the right to have an attorney with you. And so I get this question, actually, that's a great question now that I'm thinking about it. Oftentimes people are arrested and they feel like it's not a valid arrest unless unless the officer reads Miranda rights to them. That's not the case. So Miranda rights are exclusively about whether a police officer can question you. If you're arrested, they don't have to read you your rights. Before they question you, they have to read you your rights. So again, if you go back to being arrested and placed in the back of a squad car, oftentimes the arresting officer won't ask you anything. They'll just sit in the squad car with you or put you in the back of the squad car. It's not until you get to a police station that a sergeant will come and interrogate you. There are some exceptions. Sometimes the arresting officer will ask you some initial scene questions, and you can, again, I think at any point where an officer is questioning you, the wise move is to say, I would like a lawyer. I don't want to talk to you. But if you are arrested and placed in the back of a squad car, you should be able to avoid interrogation. You just have to make sure that you are remaining silent. Remain totally silent. There's nothing, I've never seen anybody benefit from talking to the cops, if I'm being honest with you.
Being in the back of the squad car is a great time for medicine.
People do that a lot, actually. I think it's a stress response. It's kind of remarkable.
Mine's also to defer. So the first one I have is what happens if you get into an accident with a government-owned vehicle such as a police car?
If you get into an accident with a police car, if you get into a car accident, like hitting a police car?
Or a police car hits you.
Sure. You have a duty to drive with due care, as does the officer. I would say I wouldn't assume that you're going to get busted if you get into an accident with a police officer. That would be a point where you're probably hyper cooperative. If a police officer is responsible for the accident, what you're going to want, again, it sounds repetitive, but badge number, squad car, all of that information. There is squad video. I mean, one of the benefits and drawbacks of modern times is that everything's on video. So you would want the squad video, and you'd otherwise treat it like a normal car accident. You would say, call your insurance company and talk to them, ask them to retrieve all of that information. Your car will probably have data that your insurance company can utilize. One thing I should tell you about, this is kind of a apropos of nothing, but I just had a case with a Tesla. It was a car accident. It was a terrible, horrible car accident case involving a Tesla. But Teslas, Jesus Christ, you guys, they record everything. I mean, it's kind of amazing. If you want to think that like Big Brother is watching you, certainly if Big Brother is named Tesla, Tesla is watching you. It was kind of amazing. Interior cameras, exterior cameras, cameras from every single angle. You could see how much this guy turned his wheel, how much his brake was depressed or gas was depressed, where he was at any time of the day. Similar to the cell phone data, like Tesla is collecting a lot of that information. Most cars are. I mean, most cars have a black box, but it's kind of, I was really shocked when I received discovery in that case because it was truly everything he had done all day in that car.
This one's unrelated, but so can you go over the Minnesota constitutional rights and the current executive orders in place?
All of them?
Well, like, important ones.
So the Minnesota constitutional rights generally mirror federal rights, things that are unique to Minnesota. Minnesota is very sacrosanct in First Amendment rights. First Amendment rights are broader than federal, and they're more specific to things like not establishing religion or freedom of assembly. I don't remember their language off the top of my head, but it is more specific. There's more specific language about indentured servitude. So one thing that people sometimes are surprised to hear is that through the 13th Amendment on the federal Constitution, slavery is still legal if you are incarcerated. So if you can lose your freedom, and you can also lose your freedom to get paid for work. That is also true in the Minnesota Constitution, but it is far more restricted. So that's an example of how they differ. Minnesota has a similar and has been interpreted as stronger right to be free from illegal search and seizure. So those are some examples of things that are greater protections under Minnesota law.
Just as a footnote to that, in terms of the 13th Amendment in Minnesota, there is a group right now that is doing work to lobby the Minnesota legislature to change the 13th Amendment in Minnesota so that slavery in incarceration is actually illegal. And one of the professors here at the school, Gabriel Lindell, is part of that group. If you were interested in helping change that law, you can speak to Gabriel, and he would be happy to have you join the cause.
I think they've done that in California or something, somewhere.
They
It
failed.
failed. It would be expensive. I mean, I think it would have to start in a smaller state.
Yeah. If they did that in California, their economy would tank.
Yeah.
So there's a question over here.
Yeah, as far as remaining silent, would you recommend cooperating with providing identification, or even that is more than silence?
Oh, that's a good question. You do, so if a police officer stops you and they have a reason to stop you, you do have to give them your identification. Not necessarily your ID card, but you have to give them your name and date of birth so they can run you to see if you have any warrants or if there's any reason for you to be detained. If you don't give up your name and date of birth, or if they can't find you within their computer systems, then they can detain you for the purpose of bringing you to the jail to get your fingerprints so they can identify who you are. But that's the limit of it. But all you have to do is give them your name and date of birth. If they ask you your address, you don't have to give that to them. If they ask you whether you're a U.S. citizen, you do not have to tell them. If you ask them, or if they ask you other questions, where you've been, where you're going, what you're up to, none of those are fair game. Fair game.
You don't need to show physical ID or anything, just verbal identification. This is
Verbal
who I am.
identification is sufficient. So police officers, I don't know if you guys have interacted with police officers in their cars, but they have a computer system in their car that just kind of looks like a laptop. It's got all sorts of junk in it. They can access your DMV records. They can access whether you've got a restraining order out against somebody or somebody's got a restraining order out against you. There's all sorts of data. They can look up all of that information. So all they really have to do is type that information into their database, and they have everything, including the equivalent of your driver's license. That's all they're entitled to. I don't know who's next.
Got a couple over here and then one over here. Anybody over there? There's one over here. Okay. So why don't we go 1, 2, 3, 4, 5.
So my question is in regards to protesting and illegal searches on your phone. So let's say that you organized with your classmates or friends to go to a protest and your phone gets taken from you and searched illegally, and they try to access group chats, organizing with other people. Are they allowed to use? Are they allowed to force you to say something about the other people in your group?
No, they can't make you say anything. What they can do, if they take your phone, they can access information in your phone with a warrant, and they can extrapolate information from there. So the way that I most often see that used is not in protest cases. It's usually in gang cases. And what I see is some kid gets popped for, I don't know, possessing a firearm. They may confiscate his phone. They may download everything. So they use this program called Cellbrite. They freeze the phone. They download everything on the phone. That would be contacts. That would be information about what social media they utilize. That would be photographs, anything like that. The photographs, if the photographs are, Baldwin's client with 3 other people who are known gang members, that would be utilized to see what other connections they might have together. With social media, they can identify where the social media account is located. So it's on Snapchat, it's through this email address at this VPN number. So we can figure out what account is attached to this phone, and we can gather information from that. This is especially something that's utilized with Facebook. A lot of people use Facebook Messenger, and they can utilize Facebook Messenger to figure out who you're talking to. Same thing with Instagram, Snapchat. Oftentimes people will try to use those platforms as a way of being more secretive, but that doesn't seem to work. Signal is good. I've never seen Signal used in court. Yeah, but well, you figure they'd crack through it sometime.
They'll figure that out.
Now, considering the fact that we're about to enter Donald Trump's second term, where he has more fascist ideologies, and we are now seeing step 2 of fascism in our country, what or how should we go about knowing our rights in a place and time where they might not matter?
That's a good question. That's a really good question, and one that I've been thinking a lot about recently. I don't think your federal rights are your federal rights. The federal Constitution is not going to change. Your right to be free from illegal search and seizure, your right to for your First Amendment protections, to assemble, to protest, to worship. All of those are, I don't think are going to be changed or are going to go away. They may be reinterpreted. If they're reinterpreted federally, it's hard to predict exactly how that's going to go. I would expect that your First Amendment rights are not going to be interfered with. I think your Second Amendment rights are rock solid right now. My guess is that your Fourth Amendment rights are not going to be interfered with. Eighth Amendment right to be free from cruel and unusual punishment, I can't predict. What I think about when I think about how to exercise your rights, I would exercise your rights for right now with the expectation that you are you're fully able to exercise your rights. I wouldn't shirk down. I wouldn't shirk back. I wouldn't shrink back from exercising your rights right now, especially in the state of Minnesota. And again, when you think about it, the federal Constitution is something that the federal government can interpret, can control, can create ways of reading that are contrary to how we've been interpreting our rights so far, right? Minnesota's Constitution is going to have broader protections and is going to oftentimes give you a greater sense of security. So in the state of Minnesota, again, even if the federal interpretation changes, the state interpretation is generally far, far safer and far broader and gives you more protection. So I think you have to remember that you have a second layer of protection.
If I can add one thing onto that, this is not the first time in the history of the United States and its Constitution that there have been kind of broad pushbacks against more authoritarian notions of what is legal. And actually, it's up to us in these moments to challenge the interpretation of the Constitution and our rights, so that legislatures and courts and what have you need to make a move and push back to say whether they think the Constitution is valid. So it's up to us testing these things, unless Trump just declares martial law and everything's off the books. And I just kind of don't see that happening, but maybe so. But like, that's what the Constitution is there for.
Right. I agree completely. And I don't think that there's going to be martial law or anything like that.
I do think they're going to try to stretch the notion of what they can legally do, but again, that's why we need to push back.
I think that the bigger question, the area that I think is ripe for pushing and protection right now, is my expectation. So legally, a person who is an immigrant has the same rights as a citizen, and when it comes to expression, when it comes to being free from illegal search and seizure, when it comes from to any of those constitutional protections. The government should not interfere with a person, whether they're a legal citizen, whether they have a green card. Those rights are supposed to be sacrosanct. I believe that that will change for immigrants. That's just how I'm reading the tea leaves. So I think that if I am somebody whose rights are not going to be impaired, I have a greater obligation to protect the rights of somebody who could be impaired. And I think that that's where an area of protest will be developing very quickly.
What are the marijuana laws in the state of Minnesota right now? Because I mean, most of us know it's a legal substance, but there is a lot of like fuzzy gray area where it's like it's legal, but there's a ton of rules you have to follow.
Yeah, it's changing. I think it changes next year. Isn't there? I think the law came into effect this year. It was ratified this year, going into effect next year, which will allow for marijuana flower to be sold in stores if you have like the license for it or whatever. In terms of marijuana law currently, it's not illegal to possess marijuana up to a certain amount. It used to be 42.5 grams. I think it's more now. I don't remember off the top of my head. But it's not technically illegal. If you were to be caught with marijuana flower, it would be considered similar to a ticket. So you'd have to pay a ticket, but it wouldn't be a crime. If you're caught with a greater amount, it could be a gross misdemeanor. If you're caught with like a couple pounds of marijuana, that's going to be a felony. There are times when the feds get interested in marijuana, but it's been a while since that's been the case. I don't know what Trump's going to do, frankly. I mean, like there's been all this push to like ease off on weed, but I don't know if that's going to be something that he supports or not. So that could change. Minnesota does protect people. It's not illegal. It's not technically illegal here. You can have gummies and other things with THC if you're over the age of 21. And I know it's going to change in the next year, but I don't know how it's going to change.
And then to follow up, kind of what are the search laws surrounding marijuana? Because I know there used to be a ton of discussion about like search on sniff.
Yep.
Okay.
Yeah. A good friend of mine litigated all that stuff. It was good. So it used to be that the smell of marijuana would be enough to allow a police officer to search your car, as an example, or search your person. The question that was litigated was whether it was burnt marijuana or fresh marijuana. We litigated the strength of marijuana, if it's like a faint smell of marijuana versus a strong smell of marijuana. With the legalization of marijuana under certain circumstances, the police officers have to have a little bit more information to search a car. So the mere scent of marijuana is not going to do it. If somebody is actively smoking weed in the car, like if you Cheech and Chong it and like you roll down the window and the plume of smoke comes out, then that would be a reason that they could search the car. But if it's simply an odor of marijuana alone, they would have to have some other feature that they can articulate in order to search the car. So one thing that's sort of interesting about how police officers interact with people is that in order for them to stop you and search you, they have to have what's called reasonable articulable suspicion. That's a legal term. In order to seize you and actually like arrest you, they have to have probable cause. Reasonable articulable suspicion means something greater than a hunch. It can't just be guessing, but it has to be something that they can identify. But something that they can identify doesn't have to be a crime. It can just be like, you're sketchy. And I can say you're sketchy because X, Y, and Z. So because I'm a cop, I understand what X, Y, and Z mean, and therefore I'm gonna stop this guy. So an example would be if you're in a high drug area and you interact with somebody with what's called furtive movements. Furtive movements mean like, if I walk up to you and I go like this, that could be considered a furtive movement. It doesn't have to be anything weird or sketchy. It could be shaking somebody's hand in the wrong place at the wrong time, being the wrong color, or wearing the wrong clothes. It has to be something that they can articulate as suspicious. It doesn't have to be a crime.
So let's do maybe like 2 or 3 more, and I know there were 2 already over here. So let's start with you and then move over.
I have a question regarding like self-defense. Because I was watching a video the other day about like a woman who had a baseball bat in her car like as like self-defense, and her friend who's a lawyer was like, hey, like actually like I don't know if that's necessarily a good idea, because like if you ever did have to be in a situation to use that, they could argue that you could get charged like if you had it in your car with like a preemptive attempt, like intent to harm. So like I don't know, like I guess my question is like, in terms of like self-defense, like is it just better to like stick with things like pepper spray, or like what is like the safest like self-defense weapon for someone to have to where you did have to use it, you wouldn't like get in trouble?
Sure. No, that makes some sense. So the question is, how does self-defense, I guess I'm going to phrase it as, how does self-defense work, and what is the best way to defend yourself without finding yourself in a world of trouble in terms of the law? So self-defense, in order to argue self-defense or to, well, let me back up. Sometimes a person acts in such a way that is illegal, but self-defense excuses that illegal activity because you have no choice but to react physically towards somebody because of whatever they're doing to you. So in order to make a self-defense claim, what you're saying is, yes, I hurt this person, or I intentionally made them afraid, but I did it for a good reason. I did it because I had to. I was protecting myself. So you have to be able to show that they were an aggressor, that you didn't provoke them, that you were in a situation where you had to act to protect yourself, that your actions in protecting yourself are not outsized. For example, if you push me, I can't shoot you, but if you push me, I can push you back, right? And that you don't have any ability to retreat. So if I have the ability to like shut my door instead of shooting you, then I would have to do that. If I don't have that opportunity, then I have the right to act in self-defense. In terms of what weapon or what tool you use to protect yourself, there's not really a right or wrong answer to that. Some people are not allowed to have firearms. Some people, in some places, you can't have mace. There wouldn't be any prohibition against having a baseball bat or any other kind of tool. I think.
Cases where people get into interactions with cops and they have something on them that is never even touched, and yet
Oh, sure.
they're charged with, and I think that's kind of part of the question that you're asking.
Yeah,
Didn't
so.
you have a guy with like nunchucks and he didn't even touch the nunchucks, but there was a charge based on the fact that there were nunchucks in his bag?
Yeah, so that would be carrying a concealed weapon, which is not actually illegal in Minnesota. That was Oregon. Here, you can, I mean, certainly if you have a weapon, that can be misinterpreted. I had a guy who had, he had brass knuckles. You're thinking of brass knuckle guy who just was wearing brass knuckles, and somebody yelled at him, and he was like, "Screw you, man." And that was second-degree assault or something like that. It was like a serious offense. Self-defense, I would say any tool can be used in self-defense as long as it is justified. So if you feel like you are threatened and you have a tool and you use it to protect yourself, then that is justified legally. You have to think about it functionally for you. You have to think about what you're comfortable with. I wouldn't, like, I hate guns. I would never have a gun, and I wouldn't use one for self-defense because I would fail at that. But those are things to consider. In terms of how people are going to interpret you, probably having a baseball, I mean, there's nothing wrong with having a baseball bat in your car if you feel like that would be necessary for self-defense. Where I've seen people get in trouble are like, I had the guy with a machete who, he used a machete like just to ward off ne'er-do-wells. That was misinterpreted, and so he wound up in jail for a while before we could get him out of that jam. So you have to worry about how people are interpreting your tool of self-defense, but there's no prohibition on what you can use.
I just had a question. So I know you are specific to Minnesota law, but like, I'm from Tennessee, and the laws of protest are getting more restrictive and have been.
Yeah.
What should we do to like be aware of this, as that might be the future of like? I know it's more protected here, but southern states not so much, and other states. What should we do to like stay like to be aware of these and how to act accordingly? Because I think some of the Tennessee laws is that you can lose your voting rights for about 45 days or something like that, and they consider riots much faster.
Sure.
I could be wrong on those, but I know those were bills that they at least tried to move forward.
Good question. So if you're going to a different state, I would say that there are two. I would utilize a couple different resources. First of all, the ACLU has branches in every state, and they have really pretty sweet, like, know your rights information. So you should be able to go to, like, the Tennessee ACLU and ask them questions, and they should have, like, a pretty readily available information. That's true of most states. Every state should have a public defender's office, and they'll generally offer you information about what is safe and what is not safe to do, and what some of the limitations or consequences of getting entangled in protest might be. Law schools oftentimes will also have like a professor or a series of professors who specialize in protest law and who can give you advice as well. So those would be three different resources if you're curious about what protections you have if you're going to a different state. I would utilize those.
One last question over. I looked up Trump's thing on marijuana, and he said some stuff about how he like opposes needless like arrests. I think I found it on an NPR article, but it says, I don't know his official stance, but it seems like he would like, I don't know, but it seems like he wouldn't like he'll try to like decriminalize it with like bipartisan support.
Oh, well, that's good, and that could be. So,
yeah,
I mean,
he could like probably leave it up to like state rights, or like up to the states.
I think that's, well, so maybe not. I mean, like, what's true is that the federal registry, like the feds do determine what is a scheduled drug, and marijuana is considered a scheduled drug, which means that it is not something that generally federally is allowed to be sold openly. So right now, I mean, depending on how the feds choose to interpret the law and enforce the law, despite marijuana being legal in various states, the feds could kind of swoop in and take over that and say that it's not legal, because technically federally it's not legal. So the federal government does have the opportunity to control marijuana legislation. I think that functionally it would be difficult, given the future administration's like statements about state rights. I think that probably they're not going to mess with weed. But I don't know. I mean, we'll see, guys. It's going to be an exciting couple years.
I saw one question, like that was great. It's like she was raising her hand for a really long time.
Oh,
I
I'm sorry.
didn't see you. Yes, what was your question?
You mentioned earlier that people who are immigrants on visas do technically have the same rights as the average American I were hypothetically to be detained for something I didn't do or have an interaction with cop, what does that do for my visa status? Does that
Great question. So that's a really good question. So if you interact with a police officer, that's not going to interfere with your visa status. I'm not an immigration attorney, but I do deal with immigration stuff a lot, and so I would say check my work when I say this stuff. But my experience tells me that interactions with police officers will not necessarily be negative to a visa or to an ability to stay in the country right now. It is something that would have to be reported if you have interactions with immigration. If a person is seeking to remain in the country on a visa, having a conviction or an admission to an offense, depending on what kind of offense, can be considered what's called a negative discretionary factor for a person to remain in the country. That includes people who are juveniles, so if you picked up a stupid case when you're like 13, that can be considered a negative discretionary factor when you're 25 and you're seeking citizenship or you're seeking to renew your visa. If you commit certain offenses, if you're convicted of certain offenses, then that would be grounds for deportation. Some of that's immediate, some of it's not. If you are held by immigration, you would generally be held in a local jail in Sherburne County. They can hold you for a significant amount of time. It's not uncommon for people to be held up to 90 days before having an interaction with a judge that's meaningful. If there's some reason why immigration has reconsidered your visa or is seeking deportation, they can hold you until the deportation proceedings commence, or they can release you on electronic monitoring. People can be released to report every 90 days or 6 months to immigration. So you can have it's almost like being on probation or parole while you're letting immigration kind of sort out your visa status or your ability to remain in the country. There are people from certain communities, I think of South American countries, some people from Laos, some people from Somalia and that area of the world, where they may be eligible for deportation because of police interactions and conviction history, but we aren't deporting. However, a lot of that is loosening up. I think will loosen up again under Trump, so I expect that there will be significant deportations and that the rules of procedure with immigration status will be changing. However, there is still a requirement for due process. A conviction is really what they look at when they're talking about deportation or negative discretionary factors in allowing somebody to remain in the country. Mere police interaction would not be enough to prevent a person from remaining unless they are undocumented.
Okay, let's all thank Ms. Baldwin.